deadly conduct with a firearm, which is a lesser included of aggravated assault with a public servant. So sentencing him on all three counts would violate his double jeopardy rights, Judge.
All right, and state, are you waiving that count?
Judge, no, the state's position is that we don't believe it's double jeopardy and that we'd like to proceed on both for punishment.
All right. So state, you're not in agreement to waiving that?
No, Your Honor.
Okay. All right, and I'll make my ruling in just a moment, but what's your next point?
Well, the next thing depends on your ruling on this, Judge. If you deny my request now, then I would say count three, they convicted on 2 paragraphs, I believe, which we all discussed. You can't have more convictions than counts. And so the court would have to strike either paragraph A or B. And so if count 3 is not being struck for double jeopardy purposes, then either paragraph A or B does need to be struck, because there cannot be 4. You can't have 4 convictions on a 3-count indictment and then be sentenced on 4 convictions on a 3-count indictment.
And Judge, the state's in agreement. The state would
waive it. Okay. Yeah, but the vehicle as opposed to the 2 people we have to be.
Okay.
Judge, we would be in agreement of waiving paragraph B, which is the individuals Acuna and also Jaime's, and proceeding on paragraph A, which is the vehicle.
All right. Then count 3, paragraph B, the state has agreed to waive that paragraph.
Okay.
Yes, Your Honor.
And then just for
well, just 1 second.
Sorry, Judge.
So any objections to the agreement to the state to waive paragraph B of count 3?
My only objection is that I think that count 3 should be struck in altogether due to double jeopardy purposes. So
I understand your argument, but I'll move towards the entirety of count 3. But
Okay.
first, is there any objections, or are you in agreement to the state's waiver of count 3, paragraph B?
No objection, Judge, but just for purposes of the record, I'm not waiving the double jeopardy argument.
No, I understand.
Thank you, Judge.
So count 3, paragraph B is waived. Now, with regards to the double jeopardy issue, state, you're stating that you don't believe it's double jeopardy?
No, Your Honor, and the purposes of actually waiving paragraph B, count 3 is now encompassed in paragraph A, which is a vehicle, which is different from paragraph or count 1 and 2, which are the individuals was aggravated assault was perpetrated on as public servants. So that's our position, that it's an entirely different elements and count. So we believe that it can proceed alone or with count 1 and count 2.
And Judge, if I could respond.
Yes.
So the jury's convicted him on counts 1 and 2, which are intentionally and knowingly shooting at these officers and knowing that they were officers. These officers, the facts show, were in a vehicle, and so this is still a lesser included of that offense, Judge. Deadly conduct with a firearm. It is still a lesser included, and our position is that it still violates Tyler Ashbaugh's double jeopardy if they were to be a sentencing on count 3 as well, even as currently constructed.
Okay. All right. Anything else?
Yes, Judge. We would just object to any evidence or mention of the juvenile adjudication. I believe that part of the evidence that it's still, I know we had this motion previously, but I have to re-urge it, that part of the evidence the court excluded in its ruling was punishment at this pretrial hearing for evidence that was uploaded, I believe, on March 14th, 2025. We had a hearing that was going to be before trial on March 24th, 2025. And the court said the punishment evidence will be out. So it's our position that that was untimely disclosed under 3914 Morton, and that the court's remedy was exclusion under Heath.
All right, so the only question is whether or not the punishment evidence, and I'm assuming, Counselor, you're making this argument because the state is going to seek to offer punishment evidence in this case, a prior
Yes.
judgment?
The form of a judgment, the judgment or the. Yeah. In the punishment phase of this trial, the state would seek to introduce a judgment of a prior juvenile adjudication. This enhancement was on the indictment. And so defense has had notice of it since October 31st of 2023.
All right, and the court recalls with the court rulings with regards to any evidence that had not previously been turned over. I know there were some issues with jail calls. There was some issues with punishment. Defense counsel informed the court that they would make a decision on whether or not they wanted that excluded at a later date. What the court can say is the court is finding that the defense was aware of the punishment that is the 2025 JUV 01255D, as that is actually in the indictment. So the court defense, did you have notice of the indictment?
I did have the indictment, Judge, but my argument is just that they were uploaded on March 14th of 2025.
All right. So that will be overruled, defense, and the request to completely waive paragraph 3 will be overruled.
And then
And the court will, though, waive count 3, paragraph B at the state's request, but count 3, paragraph A will remain.
and just a couple more requests, Judge, whenever you get a moment.
Anything else?
Yes, Judge. And so we would just re-urge our argument that I believe at that pretrial hearing on March 24th, 2024, the court said that the rest of the punishment evidence, I know that the court has made its ruling as to the juvenile adjudication evidence, but that the rest of the punishment evidence, which was uploaded and was not given notice of, would be out due to untimely disclosure under 3914 Morton and Heath. And I believe that would be any of the DWIs that were dismissed, the assault on the elderly that was.
Well, just a second. The DWIs that were dismissed, the court is not going to allow the dismissals of DWIs to be presented as evidence.
And I would just request that any evidence whatsoever then also not come in.
If
of the
there's some,
DWIs.
if there are other convictions, then you all have to approach those. State, or is there any other conviction?
There are no other convictions other than the juvenile card number that is in the indictment, however. I gave Mr. Navy note, so I understand the court's ruling about the DWIs, and so one of the DWIs was dismissed for insufficient evidence. The other DWI was dismissed for further investigation. And I'm not intending on calling any fact witnesses to get into any, I understand the court's ruling on those,
Yes,
but
ma'am.
I guess just depending on what the testimony is regarding the other injury to an elderly bodily injury, that case was dismissed either for complainant waiving prosecution. And so I would just approach before trying to get into that, but as of right now, just depends on the testimony of the witnesses that they're putting on.
All right, with regards to the DWIs, that won't be coming in. With regards to the injury to the elderly, whether or not that comes in, one, is going to depend on if doors are open, and two, whether or not the defense actually had notice. Because if there was a dismissal or of an injury to an elderly case for reasons other than insufficient evidence, the question becomes whether or not the defense had the facts the alleged facts of that case, the police reports, all of that beforehand.
And
If the defense did not have that, then that is not coming in whether the door is open or not.
may I elaborate on that, Judge?
Well, let's wait and cross the bridge till we come for it, because I know because I know the jury has been waiting.
Okay. My
But
argument is, okay, sorry.
if either party thinks that a door has been opened for that, we're gonna excuse the jury. And then I'll be able to take whatever evidence persons want to present on whether or not it violated the rule of notice to defense counsel. But what I can tell everybody is if the door is open and if notice was violated, then it's not coming in.
Okay, that's my understanding, Judge. That was the argument that I was gonna make, is the door couldn't be opened on evidence that you already ruled was out.
All right.
And then one last thing, Judge, I mean, there's a marijuana case that was dismissed. I don't imagine the state's gonna try to get into that. And then the last thing would just be asking to exclude any insinuation or mention of prior contact with Philip Hines on that DWI, but I believe that the court.
I mean, I've already made my ruling on whether or not his interaction with Officer Jaimes, the type of interaction would be admissible. The court's ruling was, and I believe a witness has already testified, that Jaimes had contact with him before, but it's not allowed to get into what the purpose of the contact was, if it was for an offense.
I'm sorry.
No, is there anything else?
And my request would just be that it not be gone into by the state for any reason at punishment.
No, I mean, they're not going to say he had contact with him with a DWI, if that's the information.
To the DWIs at all, because we're gonna comply by the court's ruling.
Okay.
So I don't think that's an issue.
All right.
I understand, Judge.
All right. Are both parties ready?
I just have a motion to fingerprint
Ah,
that I
Oh,
need to present.
And
to
then
the
I'm
court.
Yes.
sorry, I have to be difficult. I do
No,
have to,
there's no difficulty.
I do have an objection to this, Judge.
Yes.
And it's not any, what it is, or first I would, I guess, ask who the fingerprint expert is.
Robert Ennis.
Yeah.
Judge, I would object, because I was given a list of, I requested notice of fingerprint expert. I was given a list of 18 fingerprint experts.
Mhm.
Which also listed or any qualified fingerprint examiner with the Bexar County Sheriff's Office.
Mhm.
And then under that, fingerprint expert / custodian of records. So my argument is that is no notice when you just basically say any fingerprint expert under the sun. That doesn't give me notice of who your fingerprint expert is going to be. So I would argue that I haven't been given actual notice of who their fingerprint expert would be in this case. And I did timely request that near the very beginning of the case, Judge.
All right. State.
The state filed a response to defense's motion by filing a disclosure of experts and witnesses on February 18th of 2025, designated as an expert witness in the area of fingerprint identification. Is listed the fingerprint examiners that are currently employed with the Bexar County Sheriff's Office, and the witness that we intend to call, Robert Jimenez, is listed on that list. And so we complied with 3914, provided the agency that he works with, the address and the phone number to reach the witnesses. And so he's had notice of this.
All right. So defense, the witness that the state intends to call as a fingerprint expert, is that someone's name that is on the list you were given?
It is. It's one of the 18 names on the list, Judge, in addition to any qualified fingerprint expert and just general fingerprint expert / custodian of records.
All right. The defense's request to fingerprint the defendant will be granted. Is there anything else?
I think that was the state's request.
I'm sorry. Thank you. I am so sorry. See, I'm used to certain people being defense attorneys. All right. So the state's motion to request that the defendant be fingerprinted, that will be granted.
And Judge, would you like me to bring the fingerprint?
Yes, please. It gets hard when I'm used to certain people on certain sides and then they
Judge, do you want the witness on the stand?
No, do y'all have opening statements?
Yes, Judge.
Okay,
I sent you another link, Judge.
all right, thank you. I don't know why this link keeps going out.
It's the internet. I'll look down and it's just, there's no internet.
We're ready. Oh, this one.
It's in regards to the AC.
All right. State, are you prepared to proceed?
Yes, Your Honor.
Defense, are you prepared to proceed?
Yes, Your Honor.
All right, state, you may proceed.
We waive opening statements, Your Honor.
May I make one, Judge?
Yes, but could parties approach before?
And see if we're off the record. Okay.
State.
repeat offender enhancement allegation. And it is further presented in and to said court that before the commission of the offense alleged above, on the 8th day of February AD 2017, and cause number 2015 JUV 01255D in Bear County, Texas, the defendant was adjudicated by a juvenile court under section 5403 Texas Family Code for delinquent conduct constituting a felony offense for which the defendant was committed to the Texas Youth Commission under section 5404D2 Texas Family Code for the felony of burglary habitation force.
And to that allegation, how do you plead, true or not true?
True.
All right, thank you. You may be seated. And state, are you waiving your opening?
Yes, Your Honor.
All right, defense, you may
May I
proceed.
Good morning, ladies and gentlemen. This might be a little bit difficult for me. I've been very invested in this case, so I did truly believe in what I told you. It wasn't an act. What Tyler came and told you is what he told me. The first day he met me in my office, and as I looked at all the evidence, to me, and I respect that you took a lot of time and a lot of effort in making your decision. But to me, every bit, when I kept digging into the evidence, seemed to support the fact that he didn't do it and that their story became less and less likely. Now, if I say anything that offends you in this part, please don't hold it against me. Okay? Don't hold it against him. I can take it, and there may be a chance after this where we can talk to you afterwards. You've heard me talk plenty. I'm just gonna be listening at that point. I'm not gonna argue with anybody. I'm not here to tell anybody you're wrong. I'm just here to listen at that point. So there's only gonna be a few more times where you're gonna, hear me speak at this part. And like I said, I truly believed in this case, and so I understand that you took a lot of time, you sacrificed a lot of time out of your lives, and you came to a different decision, and I have to accept that. And now we have to ask for some form of punishment in this case, and that's up to you to decide. The Texas legislature at some point decided that juvenile adjudications can be used for a very limited purpose. They're not considered felony convictions or probation eligibility. So Tyler has submitted an application for probation, meaning he can truthfully say that he's never been convicted of a felony in the state of Texas. The only purpose that a juvenile adjudication can be considered a felony is for the purposes of enhancement. And so you still have to believe this beyond a reasonable doubt. And so this is the difficult part for me, is if you go with the enhancement and if you believe beyond a reasonable doubt, and once again, Tyler has a constitutional right to have the state prove up, the case to as you agreed they did, or any sort of enhancements. So this plea, if you don't agree with it, once again, please don't hold that against him. He has a constitutional right to have them follow, dot their I's and cross their T's. And so in order to, as you heard at voir dire, the range of punishment is enormous in this case. It's all the way from 5 years to 99, or you can recommend probation. However, if you find that the enhancement is proved beyond a reasonable doubt, it's 15 years to life. And the only way you can give somebody probation is if you find the underlying, you have to give a number of 10 years or less. So if you give a number of 10 years or less, you can recommend probation to the judge. However, if you don't and you find the enhanced punishment range, then there is no possibility of probation. We're talking about a minimum of 15. And I don't know what the state is going to ask for. I would just, I think with how you need to think about this, how you want to think about what to do. Just understand the gravity of these numbers. They're not thrown out like
I'm sorry.
candy or
Judge, at this point, I'm gonna object as to argument and not opening statements of what the evidence is going to show in the punishment phase of the trial.
All right, the objection will be sustained.
Okay. And so I anticipate that they will, try to enter some exhibits that will state a name. And I was trying to be prepared, hoping for the best, preparing for the worst while you guys were out deliberating. And so I was going over these records of what I anticipate they will try to show you. And at one point, I just kind of had to set it down because it's hard to read with this enhancement because it's going to list a name and then it's going to have a qualifier. It's going to say child. So they're going to try to take away your ability to consider probation with an act of a child. And you've heard about Tyler's childhood a little bit. You're gonna hear a little bit more now. But that's the only thing they know about his childhood. They don't know the rest of it. That his mother, drug addicted, not in a stable place until he was 7 years old. That's gonna, that's gonna cause a lot of issues for anybody. And so I just ask that you keep that in mind. You're gonna hear from his father. I don't imagine these witnesses are gonna take long. This is not gonna be like the guilt innocence stage of this trial where we're, I don't anticipate a lot of these people are gonna be extensively cross-examined or things like that. This is where you just get a little bit more context about the people and things like that. And we can get into a little bit more personal things. And so you're gonna hear from his dad, you're gonna hear from Tatiana. You're gonna hear from a probation officer that doesn't know Tyler, but is just going to explain to you the different conditions and how strenuous probation can be, the types of classes, the types of requirements. You're gonna hear from his GPS officer. You're gonna hear that Tyler's been on a GPS device for the last 3 years awaiting his trial. And you're gonna hear that he's been very compliant. He's had to earn additional liberties throughout the way. He was on full house arrest for a very long time. After a few months, he was able to bond out. He was in custody. When he was able to bond out, he was on full house arrest. And then he went from full house arrest, had to request, sometimes be denied because the case was, too fresh, and then to keep requesting, and that he was able to get his bond conditions amended to be house arrest with the ability to take his kids to and from school, house arrest with the ability to take his kids to and from school and then work, which is GPS partial. And then, I believe within the last year or a few months, he was even given GPS just tracking, which means you're not confined to any space. We just have the bracelet on you to know where you are at all times. And I believe you're gonna hear from his GPS officer that he's one of the most respectful people that he supervises. He's one of the easiest people to supervise. He doesn't give him any hassles, hasn't had any violations, hasn't picked up any arrests since this. And at the end of this, I am gonna ask you to find, they still have to prove this beyond a reasonable doubt if you're going to ignore this probation in up to 15-year range. And we're gonna ask that you find reasonable doubt and give Tyler a number that is 10 or less and recommend probation.
All right, state, you may call your first witness.
You state called Robert Jimenez. Judge, and just the rule is still invoked.
Okay.
And I see witnesses in the courtroom.
Okay.
Yes. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can have a seat. All right, and you'll make sure you keep your voice up so everyone can hear. If you'll state your name for the record, please.
Yes, my name is Robert Jimenez. I'm fingerprint supervisor and fingerprint examiner, certified in taking fingerprints for the Bexar County Sheriff's Office.
All right, state you may proceed.
Thank you. Mr. Jimenez, so you stated you're currently employed with the Bexar County Sheriff's Office, is that correct?
That's correct.
How long have you been employed with the Bexar County Sheriff's Office?
32 years.
And in those 32 years, have you been within the fingerprint identification section of the sheriff's office?
Yes, I have.
Can you explain to the jury your duties as a fingerprint examiner and then your supervisory role as well?
As fingerprint examiner, my duties include taking the fingerprints that we get when the people are placed into custody. We take those fingerprints, we analyze them, do comparisons with the patterns that are on the prints themselves to make a determination as far as an identity. We put a classification on there, and then after that, that's how we are able to identify the person.
Okay. And what training do you have in fingerprint identification?
My training, I had my training back in May 24th, 1996, Texas Commission on Law Enforcement. 40-hour fingerprint course in basic fingerprint science.
Okay, and then since then, in the 32 years, are you taking fingerprints daily in your role with the sheriff's office?
I don't take fingerprints daily anymore since I'm a supervisor now, but I oversee the process with the examiners that actually do that part of the work now.
Okay, I guess years back in your career before you were a supervisor though, were you employed as taking the fingerprints as the arrestees would be booked into the sheriff's office?
That's correct,
Okay.
for over 20 years.
Okay, and so that would be multiple people being booked in daily or analyzing their fingerprints and conducting an analysis.
That's correct.
Okay, and so can you just explain to the jury what a fingerprint is?
The fingerprints are the friction ridges that are raised on the palmar side of the fingers, and they're used for identification purposes.
Okay, and how many points of identification do you have to consider it a match for identification purposes?
We normally go for a 12. However, in the state of Texas, there is no set amount. It is at the discretion of the examiner that's making the research.
Okay, can you explain to the jury what an inked print is?
The ink prints are taken when the person's brought into the jail, and they put the fingerprints on an ink pad, and then they transfer them to the fingerprint card. And then from there, we receive the prints digitally, so that way we can make comparisons with the patterns.
Okay, and in your career, have you ever heard or found two people having the same fingerprint?
No, I have not.
Okay. Your Honor, may I approach the witness?
Yes.
Okay, Mr. Jimenez, I'm gonna show you what has been marked as State's Exhibit A. Can you tell me if you recognize that?
Yes, I do.
And can you tell me what that is?
It's a fingerprint card.
And did you collect fingerprints from someone today?
Yes, I did.
Do you know the name of that person?
The name is Tyler Ashbaugh.
And do you see that person in court here today?
Yes, I do.
Can you please point to him and identify him by an article of clothing that he's wearing?
He's wearing a white shirt with a green tie.
Okay, and is this a fair and accurate depiction of the fingerprints that you took in court here today?
Yes.
Your Honor, at this time, the state is tendering State's Exhibit number A to defense and offering the same.
No objection as to states A.
Right, states A is admitted without objection.
And Your Honor, at this time, the state offers state's exhibit number B as a self-authenticating document and under Rule 903.
Judge, I would object to this. Your arguments previously stated that it violates the untimely disclosure
No
requirement
object to this objection.
of 3914. I have to make the objection, Judge. I have to state the legal grounds.
All right, so defense, the court is aware of your previous objection.
Okay, and may I get a running objection as on that point as to everything that was discussed at the pretrial or outside the presence of the jury this morning, Judge.
All right, so your objection is overruled. States B is admitted.
But could I just get a running objection as to
Yes.
that, Judge? Thank you.
Now, Mr. Neiman, as I'm showing you what's been entered into evidence as state's exhibit number B, does this document contain a fingerprint on it?
Yes, it does.
Okay, and have you had a chance to review state's exhibit number B and make a comparison to the fingerprints that you collected today on state's exhibit number A?
Yes,
And what was the result of that analysis that you conducted?
the fingerprint that's on the document is a right thumbprint. I therefore compared it with the right thumbprint that I took just a few minutes ago. And they are, prints are identical. They're one and the same.
Okay, and so who is the person that's print is on state's exhibit number B? Whose right thumbprint is that?
That print belongs to Tyler James Ashbaugh.
Okay, and just regarding state's exhibit number B, or state's exhibit B, is there any name that is an identifier on the document?
Yes,
And what is that name?
the name is Tyler James Ashbaugh.
And then, is there a date of birth that's associated with that person? And so the result of your analysis was that the right thumbprint that's on state's exhibit number B is of the defendant Tyler James Ashbaugh.
That is correct.
We pass the witness, Your Honor.
All right, defense.
Thank you, Judge. Good morning, sir.
Good morning.
What's the scientific methodology of your fingerprint analysis?
The methodology is that we do the comparisons with comparing the patterns on fingerprints. There are different sets of patterns known as whorls, arches, loops.
Okay, and when you say compare, essentially you're looking at these fingerprints, correct?
That's correct.
And you're making a determination if they look similar.
Yes,
Okay. Would you agree with me that making that determination as to whether these specific points look similar is up to each individual fingerprint analyst?
yes,
Okay. And there is a bit of subjectivity in this science.
there is.
Okay. Are you aware of the ACE-V method of fingerprinting?
I don't recall ever hearing about it.
Okay. Analysis, comparison, evaluation, and verification?
No, I haven't.
Okay. Are you aware that that's the standard method of fingerprint analysis?
No, I was aware.
Okay. And so you compared these two sets of fingerprints this morning, correct?
That's correct.
Okay. And when you took the fingerprints this morning, you took them from Mr. Ashbaugh.
Yes,
And so are you aware that the V in ACE-V stands for verification?
yes,
Okay. And essentially with that step, it requires that another analyst independently verify the conclusion of one fingerprint analyst, correct?
that's a method, yes.
Okay, but that method was not done this morning.
Not this morning, no,
Okay, so the ACE-V method was not
implied.
complied with. All right, I'll pass the witness.
No further questions.
All right, is this witness excused or subject for
Excused by
recall?
the state.
Excused by the defense.
All right, thank you. You may step down.
Thank you, Judge.
If you leave the exhibits with the court reporter, please.
I've placed them over here.
All right, thank you.
Thank you.
All right, state, call your next witness.
No further witnesses, Your Honor.
All right, defense.
Defense calls Tatiana Martinez de Escobar. I'll go get her.
All right, and if you'll put that square microphone on again, please. You're still under oath. If you'll restate your name, please.
Tatiana Martinez de Escobar.
All right, defense, you may proceed.
Thank you, Judge. Good morning.
Good morning.
So now that this is the second phase of the trial, there's a little bit more things that we can get into. So I'm going to ask you a little bit more personal questions about Tyler. Is that okay?
Okay.
Can you describe the kind of dad that Tyler is?
Tyler's very attentive. He's loving beyond measures. He's patient. He's a patient father.
Now, when Tyler was on full house arrest, he was unable to work, correct?
Yes, sir.
And so did the roles kind of reverse where he stayed at home with your daughter and you went outside the house and worked?
Yes, sir.
And how was he as a stay-at-home father during that period of time?
Graceful. He took the challenge very gracefully. Gratefully. He's always been grateful to be able to stay home with our kids.
And has he tried to make things like easier on you as a mother?
Yes, it was always the intentions for us to have me stay home. Even though I wanted to pursue a career and go back to school, he still wanted to get a job. He tried to still get work release so that he could work and so I could stay home.
Okay. How would you describe his relationship with you? Because I know a lot of this trial focused on May 22nd, 2022, and in the past. Since he was arrested and placed on house arrest, how has his relationship with you changed?
Immensely. We've both changed so much. Our families have changed. We're more focused.
How would you describe his relationship with your son?
He is my son's sole caregiver. He is my son's everything. He does everything for him. I currently breastfeed, but I go to work full time. And sometimes I'll come home and my son still won't even want anything to do with me. He just loves his dad. He's very attached.
Sounds like he's more, not to, no offense, but he's more attached to Tyler.
Yes.
Okay. When did you meet Tyler? How old were you?
I was 11 when I met Tyler.
Okay, so you were both pretty young. And when did you two start dating?
When we were 11.
When you were 11, you started dating.
Yes.
And so you've been together all the way since then.
Yes.
What do you know about Tyler's life before he was 7?
I know that he was taken in by his godparents. I know that his mother was just not in the most stable of living conditions, or mental conditions, and he was, given to his adoptive, I don't think legally adopted, but his guardian, his parents, his godparents.
So when you say parents, who are those?
Joe Gonzalez and Norma Gonzalez.
Okay. What issues has Tyler's biological mother struggled with in her life?
She struggled with addiction and with homelessness.
Do you believe she was a good mother to Tyler?
I hate to be one to say that someone's a bad mother as a mother myself, but I don't believe she did everything that she could for Tyler as a mother.
How was Tyler handed off to, or maybe not handed off is the wrong word, but how did Tyler come to live with Norma and Joe? What's the connection there?
His biological mother had attended a school where his Norma taught. She was a college professor, an English college professor, and she was her student. He was brought to class through a work study kind of deal, I believe. So he attended those college classes with his mom when he was probably less than a year old, maybe less than 2. That's how they came to meet Norma and Joe.
And when his mother had issues, she gave Tyler up to her professor and her professor's husband, which are Joe and Norma.
Yes, along the years, they had tried to help Joy, his biological mother.
Okay. How would you describe Tyler to somebody who hasn't spent any time with him?
Kind. He's so kind, and he's so loving and generous and forgiving.
And with you, is it fair to say as well?
Yes, very forgiving with me.
Okay. What types of things has Tyler been? What type of activities has Tyler engaged in since he's been on GPS tracking and has a little bit more freedom?
He was allotted tracking. The first thing and the priority of his mind was going to Helotes to visit with his younger brother and sister who were separated from him, and go to church every Sunday.
Okay. How many brothers and sisters does he have?
2.
Two?
1 brother and 1 sister.
And you say separated, can you explain that?
So by the time Tyler was already living with Joe and Norma, his mother had met somebody else and had 2 children with that person. She continued down her path of drug abuse and homelessness, and eventually got those children taken away from her as well.
Okay. Have you heard of anything that she engaged in while Tyler's biological mother was pregnant with Tyler?
I'm sorry, can you elaborate?
Have you heard of any activities that Tyler's biological mother engaged in while she was actually pregnant with Tyler?
Ginger, I'm going to object to this question as calls for hearsay and lack of personal knowledge.
And
Yes,
I don't believe it's hearsay. I'm just asking if she's aware.
right, the
There's no
objection,
statement that's being offered for the truth of the matter asserted.
all right, the objection will be sustained. You may ask your next question.
Thank you, Judge. If you could just give me a minute or a few seconds. Does Tyler know his biological father?
Yes, Tyler does know his biological father, but he has never met him in person.
He's never met him in person.
No.
How old was Tyler when there was any contact between him and his biological father?
I'm not too sure. I know throughout the years when he was younger, he had periodically heard from him over the phone. Once I got pregnant with my daughter, he began speaking to him regularly over the phone.
So only very recently.
Yes.
Okay. That's witness.
All right, any questions?
Just briefly, Tatiana, so obviously, you're married to Tyler currently, right?
Yes, ma'am.
And you all got formally married in 2024, is that correct?
Yes, ma'am.
Okay, and your son was also born last year in 2024, correct?
Yes, ma'am.
And you have another daughter with him, right? That's older than your son, correct?
Yes, ma'am.
And so obviously you love him a great deal, right?
Yes, ma'am.
And you guys have formed a family with each other and you care for him. You don't want to see anything bad happen to him, right?
That's correct.
Okay. So since you've known Tyler since you all were 11 years old, you knew him during the year 2018, correct?
Yes, ma'am.
And have you heard of the time that he was committed to the Texas Youth Commission?
I'm gonna object, Judge, under the same ground stated earlier, 3914, Michael Morton and Heath.
All right, that objection will be overruled.
Could you repeat the question, please?
Yes, ma'am. Did you know Tyler during the period of 2018 when he was committed to the Texas Youth Commission?
I believe so. I'm sorry.
No, that's okay. So I guess there was an incident that happened back in 2015 where Tyler was accused of breaking and entering into a home without consent. Are you aware of that?
Yes, ma'am, I am.
Okay, and he was also in possession of a deadly weapon when that occurred. Are you aware of that?
No, ma'am. it was not.
Objection, facts not in evidence.
It's in the document.
Can I see State's Exhibit B, please? All right. State, you'll ask your question, please.
Yes, Your Honor. And so I'm gonna rephrase a little bit. So you're aware of the breaking and entering in the home, correct?
Yes, ma'am.
Okay, and so are you aware that Tyler was placed on juvenile probation for that?
Yes, ma'am.
Okay, and at some point in 2017, his probation was revoked because one of the conditions of his probation was to not be in possession of any deadly weapons. Were you aware of that?
Yes, ma'am.
Okay, and were you aware that his probation was revoked because in 2017 he was in possession of some type of deadly weapon?
Yes, ma'am.
Okay. And then back in 22, around the time that this offense was happening, are you aware that Tyler was engaging in the sale and distribution?
Judge, I'm gonna object.
Just 1 second. May I see State's Exhibit B?
So Tatiana, were you aware that around the time of the offense on May 22nd of 2022, Tyler was knowingly possessing with the intent to deliver marijuana?
No, ma'am, I was not.
Okay, and so would it surprise you to know that he told Detective Tudor that he would sell marijuana for extra income during this time?
No, it would not surprise me.
Okay, so were you aware that this was behavior that he was engaging in?
I was aware that it was behavior that he would engage in,
Okay,
but as far as my knowledge, no, he did not bring that to my attention. It was not anywhere where I could see it.
okay. And just regarding, I mean, do you believe that Tyler should be held accountable for his actions on that night?
Judge, I'm gonna object that it calls for, it calls for speculation and a legal conclusion.
The objection will be overruled.
Can you repeat the question?
Do you believe that Tyler should be held accountable for the actions that he engaged in on May 22nd of 2022?
Of course I do.
Thank you. We pass the witness.
All right, defense.
Very briefly, Judge. Martinez Escobar, you've been with Tyler for quite some time, correct?
Yes, sir.
No matter what happens, whatever the jury sentences him to, is it your intent to support Tyler and stay with him?
Of course it is.
Pass the witness.
No further questions.
All right. Is this witness excused?
Yes, Judge.
All right, you may step down. Defense, call your next witness.
Defense calls Joseph Gonzalez. And Judge, if the witnesses are excused, may they remain in the courtroom?
Any objection?
No.
Yes, they may remain.
Hello, Your Honor.
Hello. If you'll put the square microphone, it's the little square microphone that's in front of you. If you'll just put it somewhere on your shirt, please. It's for the court reporter to hear.
Okay, can you hear me?
Yes. All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right, you can lower your hand, and if you'll state your name for the record.
Joseph E. Gonzalez.
All right, you may proceed.
Thank you, Judge. Good morning, Mr. Gonzalez.
Good morning.
So in the previous phase, we've been talking more around May of 2022. Since then, after the arrest, can you describe if there's been any change in Tyler, if there's, and just describe how he is as a son since then?
Okay, after the incident that happened, yes, it was very hard for us at the beginning. But we stood together as a family, my wife and I and Tatiana. Was under the house arrest with us. And he stayed at the house. He didn't get involved in any outside activities at all. Made his dates with the probation officers requested. His attitude has changed. He became more open in discussion with my wife. And they talk a lot. He expressed his feelings of remorse of what he has done. And that it was an incident that he wished he could have taken back. Because it was something that was very spontaneous that happened to Tyler, I believe. He's a good son. He's very helpful. He helps me a lot with my wife, Norma, who's ill. He has a real bad back problem. And Tyler has this training in some medical field that helps me with her, especially since I have become more weak in myself because I'm diabetic and I've had my medical conditions as well. But Tyler has helped me with several times when my wife has fallen and helped me up because I didn't have the strength to pick up my wife. And so helped us with the care when she needed it. And myself, when I got sick and had some amputation, he took care of me as well. He is a son that is very intelligent, and we love him very much unconditionally. We're sorry at what has happened. And as a family, we still bonded and to stay together. We're not bitter. We're just grateful that he's still alive and is with us. He has a family now. He has a son that was just born last year. And he has a daughter, Davina. He has a loving wife, Tatiana, and very helpful. Within the last 3 years, he's been very helpful with Tatiana, with helping her with her education and her nursing training. So it's been difficult for Tyler because he was under the house arrest of not being able to work. So he's had some strenuous times about that. But he has been helpful around the house. He's been a joy to be around with us and the family. And we love him a lot, very much. I don't know what else to say except that we will always care for him and the family. And wish that we could have him here at my house now.
Do you believe Tyler's matured a lot in the last 3 years?
He has matured a lot. He's been doing a lot of reading. He does a lot of discussion with my wife. My wife was an English professor at San Antonio College. So they talk a lot. They have good communication with each other. They discuss a lot about life, about how to be a better person, how to be a good citizen, and understand that things that went wrong and how we can do things right, he can do things right. I believe he can now. But it's been difficult this last 3 years. It's been strenuous, it's been on his mind, and he was able to find religion again. His early school years were at a Christian school. So he knows, and now is falling back on that faith again, and has helped clear his mind a lot more than doing anything that is wrong or evil or not right, and becoming a better citizen and a human being in this world. He knows the value of family life. He knows the value of being a good father, and he is a good father for his children right now. He helps them. He's educating Davina very well. He now has the care of his son, Draven. And he's a good father in managing his care and his health and taking care of the baby as when Tatiana goes to work. So I think he has changed immensely, so much that we have a lot of faith in him. And we think that he can become the better person that he's becoming right now. Again, like I said, constantly unconditional love we have for him.
Can you describe how he came into your care and you became his father?
I'm sorry,
Can you describe how Tyler came into your care and you became his father and he became your son?
my wife taught at SAC and she helps a lot of her students over there at, excuse me.
Okay.
Way down here. My wife taught at SAC, she had a student, and she cared a lot about her students, so she helped Tyler's mother. She got him in the work study program at school. She was taking courses, English courses with my wife. Then after a while, she dropped out of school, and she came back and she brought Tyler. And my wife fell in love with Tyler. So we became very close. But Tyler's mother was not a very, well, she was a loving mother, but she was very unable to take care of Tyler. There's Tyler's grandparents always asked us to adopt Tyler at that time when he was a baby. We didn't feel right of separating family at that time. So we eventually, in 2007, when Tyler's mother was not able to take care of him, we brought him into the family. And we cared for him. We took care of him. He was 7 years old at that time, 2007. And we took him to his school in Northern Hills Elementary School. We went to high school to River City Christian School. And we brought him up. We still was in contact with his birth mom, but I think we kind of in hindsight, we had an error that we would let him go to his mother on the break from school during the summer. And it just turned out it just was a bad influence that he had from his mother's side and a gentleman that lived with his mother. But other than that, he grew up pretty intelligent, did fairly well in school. And we did have some other problems with him before, but he was able to overcome that. Did fall in love with his junior high sweetheart, Tatiana, and we've seen them grow together as a family. And understand that, they love each other very much. We are now grandparents, like I mentioned. We have a granddaughter and a grandson. Though they're not our blood, they feel like he's our blood. We raised him. We love him. We want the best for him. I apologize as a father. Maybe I didn't, it wasn't good enough. I have my errors as well, but I do love him very much. My wife loves him very much, Norma. Anything else, sir?
You give me a second.
Uh,
If this jury were to give Tyler any sort of probation, would you do everything in your power to try to make sure that he complies with all the conditions as he's been doing on pretrial release?
Yes, we would do that. We also would be still responsible for him getting another post-education to find a good position that he would want to work in and a career field that he would love. He has talent in health. He has talent in cooking as a chef. He's well read and he's very intelligent. He's able to work on the computer. He's able to write and type. His signature name may not be legible, but he can read and write and type and understands, very intelligent. He knows some Spanish. He gets along with our other immediate family as well. So I believe he could be a much better person
I'll pass the
and
witness.
continue to be at this stage.
I'll pass the witness.
All right, state.
Mr. Gonzalez,
Yes, ma'am.
if you could just give me a second. Do you have something? Just- Do you still have the speakers with me?
Yes. Yep. Oh, that's, I believe, either your copies or Mr. Nady's.
Mr. Gonzalez, so Tyler was under your care in February of 2017 and also in the year 2015, is that correct?
I believe so.
Okay, you want to take a look at State's Exhibit number B?
I should bring the reading glasses. Which one?
So I guess I'll turn it. Just right here, so if we're looking at State's Exhibit number B, that's a juvenile adjudication judgment. Do you see that?
Okay,
And Judge, I'm gonna object at this point, renew my objection under 3914, Michael Morton and Heath.
All right, that objection will be overruled.
And at this time, yourself, Joseph Gonzalez, and Norma Gonzalez are listed as Tyler Ashbaugh's guardians, is that correct?
correct.
Okay, and so you're aware that in 2015, Tyler was detained in the juvenile system for committing burglary of a habitation involving force, correct?
Yes, he was involved with some other students at that time,
Okay,
and at that time, if I remember correctly, he took the blame for other people for this.
okay.
So
And so the facts of that offense were him and other people entered into someone's residence using force and without that person's consent, correct?
I don't know about the force. I don't remember the details on that.
Okay, and if the judgment says burglary of a habitation force, I mean, do you have any reason to doubt that?
Objection, speculation.
That objection will be overruled.
I don't know. I don't object to. Well, I don't understand what your question is. Okay,
So if the judgment right here says burglary and habitation of a force, that would be correct, right?
Same objection.
All right,
I
that'll
don't
be
know what
overruled.
force means. Does it mean? What does force mean? Breaking and entering? Does it mean with aggravated assault or?
Yeah,
what-
it means breaking and entering without the consent of the owner.
Objection to the state testifying.
All right, that'll be sustained.
Moving on, you're aware that Tyler was given probation for this offense, correct?
Yes,
Okay, and so he was on juvenile probation for a while, right?
I believe so.
Okay,
Yes.
and he was unable to comply with the terms of probation, is that correct?
What do you mean? What specifically you meant by that?
Specifically, I mean, so one term of probation is that you cannot ingest substances like marijuana or drugs. Are you aware of that?
Okay,
And Tyler was engaging in the use of marijuana during this time. Are you aware of that?
yes,
Okay, and so that would mean that he's not abiding by the rules of probation, correct?
yes, I believe I was under the influence of some of his friends.
Okay, and so probation still gave him another chance after that. Are you aware of that?
Specifically,
Okay, and then are you aware that another condition of probation is that you're not supposed to possess deadly weapons while on probation?
yes,
Okay, and you're aware that Tyler's probation was revoked because he was in possession of some type of deadly weapon, correct?
Yes, he had to have something.
Okay, and so ultimately his probation was revoked and he was sent to the Texas Youth Commission, correct?
Okay, now, by the extension of the weapon, I don't remember specifically what the weapon was.
That's okay. But I'm asking you, I mean, his probation was revoked and he was removed from your home and sent to Texas Youth Commission. Do you recall that?
Yes, I do.
Okay. And I guess during the time in the year 2022, because I know Tyler and Tatiana lived with you for some time, is that correct?
Correct.
Okay. And during the time that he was living with you, he was still engaging in the use of marijuana, correct?
That I don't know for sure.
Okay. But in the text messages that you had with Tyler, you were kind of urging him to stop engaging in the use of marijuana, correct?
When I found out maybe that he had used it one time before, he was involved with a older gentleman, I believe.
Okay. And so were you aware in the year of 2022 that Tyler was selling marijuana as a source of extra income?
No,
Okay, and were you aware that he was also engaging in the dealing of guns as he testified to during the trial?
Judge, I'm gonna object to that mischaracterization of the evidence.
remember any of
The
that.
only thing, and sir, if you could, when there's an objection, if you could stop. That's a mischaracterization of the evidence. The only testimony was that it was done with a legal bill of sale, Judge. There was no insinuation that it was done illegally or as the state's characterizing it, gun distribution.
All
And
right.
that's very highly prejudicial under 403.
All right, the objection will be sustained.
Were you aware that Tyler was selling firearms with bills of sale in the year 2022?
no,
Now, obviously, you've testified that you love Tyler a great deal. He's been under the care of you and your wife since he was 7 years old, correct?
correct.
Okay, and you don't want to see anything bad happen to him, correct?
Definitely, we did not want to.
And even though you feel like this was, I think you described it as something spontaneous on his part, this offense, do you believe that he should be held accountable for his actions?
Everyone should be accountable to their actions. It's just how strenuous or what the actions are that he has done. But I believe that he can still overcome all this behavior.
Thank you very much, sir. We pass the witness.
No further questions, Judge.
All right, is this witness excused?
Yes.
Yes.
All right, and sir, if you'll remove the microphone from your shirt.
Okay.
All right, and you are
Thank you.
excused. Thank you.
I can still do it.
Yes. All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. If you'll put that square microphone somewhere in your shirt, it's the little square one. It's for the court reporter to hear. And if you'll state your name for the record, please.
Bianca Zapata.
All right, and just make sure you keep your voice up so everyone can hear. You may proceed.
Thank you, Judge. Good morning, Ms. Zapata.
Good morning.
Can you please describe your current occupation to the jury?
Yes. So I am a supervisor for the Bexar County Community Supervision and Corrections Department, otherwise known as adult probation. I supervise the court liaison officers here in the district courts. So every district court has a probation officer assigned to it to be the bridge between the probation office and the courts.
And how long have you been with Bexar County Probation Department?
I've been with the probation department for almost 13 years.
Okay, so quite an extensive time with Bexar County Probation.
Yes.
I'd like to kind of describe the various different kinds of conditions that that can be ordered by the court if an individual is given probation. Is that okay?
Okay.
are there any, can you describe like the different mental health conditions that probation might assist with?
So we do have a mental health assessor within the probation department if the court orders them to be evaluated for our programs. We have two different programs that apply to mental health. One of them is our mental health initiative, and the other one would be DDRF, which is our dual diagnosed residential facility.
Okay, and what is DDRF, if you could explain that?
That is an inpatient program that is for individuals that have a dual diagnosis of a substance abuse and a mental health problem. And they do have to meet criteria for priority population, so that is done by a mental health assessor. And that is if the judge orders them to be evaluated for that program.
Okay, and that's actually like an in-custody program?
Yes, it is inpatient, and the timeframe would range anywhere from 120 to 180 days that they are participating in that program if they meet criteria.
Okay, and can individuals that are beginning probation be evaluated for any substance abuse issues?
Yes, so the probation department does offer substance abuse treatment, both in an inpatient and outpatient setting. And so our assessors would meet with those individuals if ordered by the judge and make an appropriate recommendation for that individual to receive substance abuse treatment.
Okay, and are there a multitude of different types of ways that substance abuse can be and is addressed through Bexar County probation?
Yes, so we have inpatient, inpatient substance abuse treatment, and then we have two levels of outpatient in a supportive outpatient program and intensive outpatient. And then as far as our residential programs, we have a local facility, and then there's also facilities within TDCJ that also offer substance abuse treatment, and that is dependent on the recommendations of those assessors.
And when you say substance abuse, does that apply to alcohol as well as illegal drugs?
Yes.
Okay, or pills?
Yes, so the assessor would have an interview with them and determine if they meet criteria for, it would be alcohol, drugs, it could be prescription, it depends. I don't know exactly what those questions are pertaining to because I'm not qualified to make those assessments.
Okay, are you describing a TAP evaluation?
Correct.
Okay, so a TAP evaluation is where the individual is assessed and then determined, number one, if they need any sort of treatment, and then if they do, what type of treatment is necessary.
Yes.
Can a court order GPS monitoring as a condition of probation?
Yes.
Okay, and they would be supervised by a probation department.
So the GPS would be installed on them. It's typically worn on the ankle. It is installed by a third party. And then there are parameters that are set for that GPS, and then the probation officer would receive any type of alerts pertaining to that GPS. So the officer doesn't do round the clock supervision. It's just based off of that information coming from that third party.
And can drug testing be a condition of probation?
Drug testing is a standard condition of probation. So anyone that's on community supervision would have a condition probation that's standard, that they cannot use drugs or alcohol while they're on supervision. They do have to submit to drug testing, and then it is expected that they pay for their drug testing.
Okay, and can somebody be required to do either regular or random drug testing?
Yes.
Okay. And now what happens if an individual violates conditions of probation?
So if somebody violates our conditions of probation, the probation department, our goal is to address those behaviors. And so we would have to assess what these violations are that occurred. There are instances where we can address those violations in-house. And we always do notify the court of whatever interventions we are utilizing. But there is also instances where a violation may be serious enough that we cannot address it ourselves, or it may be that they're just not being compliant with what we've attempted. And so then at that point, we would submit a violation report to the state, and a motion to revoke their probation would be filed if appropriate.
And when a motion to revoke probation is filed, does a warrant go out for the arrest of that individual?
Yes, a warrant is issued when an MTR or motion to revoke is filed.
And when that individual is arrested, do they come back to the same court where they were sentenced?
Yes, so the court retains jurisdiction over that case. So if somebody was supervised or ordered probation out of one court, they typically would go back to that same court to make a determination on how to address that violation.
Okay, and then does the individual have an opportunity to plead true or not true?
Yes,
And then and who makes the determination at that point if the individual has violated the terms of the probation?
that would be the judge.
Okay, and once the judge makes that determination, who makes the decision as far as what happens to that individual, whether their probation is revoked or whether they can continue on probation?
That would be the judge.
Okay, so the judge at that point has a very wide range of discretion, is that fair to say, on what to do with
Correct.
the case?
Correct. So the probation department would make recommendations and then there's generally discussion to see if there could be an agreement made but they still have to present that to the judge and the judge will make that final determination.
Okay, can you describe, let's say, what 10 years TDC, Texas Department of Corrections, probated for 10 years means?
So 10 years, TDC probated for 10 years of probation would mean that that individual is ordered to, their underlying sentence is 10 years. So anybody that's on probation, they cannot have an underlying sentence more than 10 years. So the maximum underlying sentence would be 10 years, and then that person would be on probation for 10 years.
Is 10 years the maximum time somebody can be on probation?
Yes.
Are there still instances where somebody could actually be extended beyond that 10 years?
No.
Okay, and what's the minimum amount of probation that somebody can be placed on in that situation?
The minimum amount of probation for if they had a 10-year underlying?
Well, let's say it's a first-degree felony. And if you don't know, it's
I don't know that.
okay, but the maximum is up to 10 years of probation.
Correct.
Okay. Okay, and so if somebody was sentenced to probation in this courtroom, the 187th, and who makes the final determination on what the terms and conditions of that individual's probation are?
The judge.
Okay, and can the judge amend those conditions at any time?
Yes.
Okay, and the judge can also do that without a violation, is that correct?
That is correct.
Okay, so that if the judge thinks it's in that person's best interest, the judge could add further conditions.
Correct.
Is Alcoholics Anonymous a possible condition?
Yes.
Narcotics Anonymous?
Yes.
And so, and I don't know if I asked you this already, so if somebody was sentenced in this court and they had a motion to revoke their probation, would they come back to Judge Boyd?
They would come back to the 187th District Court.
To the 187th District Court, and the judge of the 187th District Court would make a decision on whether that individual's probation is revoked and sentence them to anywhere, they can be sentenced to anywhere in that underlying period of time, correct?
Yes.
Or if they're continued on probation.
Correct.
Are there any significant conditions of probation that I haven't gone over with you that are available to somebody?
I mean, there's a number of standard conditions of probation, and I mean, I would say that each one of them is significant. So those conditions can range anywhere from not being arrested again, not committing new offenses, to not leaving the county. So, I mean, every one of the conditions we do take serious as far as making sure that those probationers are following those conditions.
And is one of the standard conditions of probation to not possess firearms?
Yes.
And is one of the standard conditions of probation to actually not drink alcohol, period?
Correct.
And not do drugs, period.
Correct.
And if somebody is convicted of an offense and placed on probation, by law, they could be arrested for another felony if they possess a firearm.
Correct.
Okay, I'll pass the witness.
State.
Yes, Your Honor. Good morning.
Good morning.
I think we know each other very well.
Yes,
Is that
sir.
correct? We deal with each other on a daily basis.
Yes.
So I'm gonna show you what's marked State Exhibit B. Now, can you just flip through that and tell me if you're at least somewhat familiar? I know you might not be familiar with this particular item, but you would be aware of these type of paperwork. Is that correct?
And Judge, I just reiterate my same objection under 3914, Michael Morton and the Heath case.
All right, that objection will be overruled.
So these appear to be legal documents, but I'm not familiar with them.
And as in familiar with them as in this particular set of paperwork, or have you seen paperwork like this?
I personally have not seen paperwork like this.
And is that because as the state exhibit number B, this is the part of a juvenile system, is that correct?
Looking at page 1 of this, yes.
And it's associated with, obviously, this is already in evidence, but it's associated with the Tyler James Ashbaugh, is that correct?
Correct.
And going through this, you see in particular motions in a sense to motions to modify. Now, there's a different type of language that they use in the juvenile system opposed to the adult system. Is that correct?
Seeing this, it appears to be.
Okay.
So.
And in this particular case of this individual, Tyler Ashbaugh, he was charged with and convicted of, well, I don't like using that terminology because that's the adult terminology. But in this particular case, the offense of the felony of burglary habitation by force. Is that accurate to say?
Looking at this documentation, that's what it reads.
And again, you never have done juvenile probation, have you?
I have not.
You're just adult probation.
Yes.
Now, you stated earlier that your testimony is that as if the jury or the judge asserts 10 years or lower, that individual can be put on probation. Is that accurate to say?
Right. If the underlying sentence is 10 years or less than 10 years, then they would be able to be on probation if it was granted.
So if the individual had a prior conviction, that what we call a repeater enhancement, and the minimum is 15 years, that individual cannot be put on probation. Is that accurate to say?
If the minimum sentence for an offense would be 15 years, then they could not be put on probation. Because the underlying sentence has to be 10 or less.
So if a prior conviction was proved of, and the minimum is 15 years, by law, they can't be put on probation. Is that accurate to say?
So if their underlying sentence cannot be 10 years or less, then they wouldn't qualify to be on probation.
And in your experiences, individuals that had previous probations and did not finish them successfully, are those individuals good candidates for probation after that?
So unfortunately, I wouldn't be able to make that assessment. We try to look at everybody individually and see how that is determined. So we kind of want to have a fresh take on it. So I wouldn't be able to say that would make somebody a suitable candidate or not a suitable candidate.
Thank you. We'll pass the witness, Your Honor.
Briefly, Judge, may I approach the witness? I'm going to show you, ma'am, what's been marked as Defendant's Exhibit A. Can you tell me what this is?
It says it's a written sworn motion for a community supervision jury.
Okay, is that a standard form in this court?
I have not seen this before.
Okay, and is it, does it have a file stamp from the clerk?
Yes,
Okay, indicating that it's sworn.
yes.
Okay, Judge, at this time, I would tender Defendant's Exhibit A and offer an evidence.
No objection, Your Honor.
All right, and what exhibit number is that, please?
Defendant's Exhibit A, Judge.
All right, defendant's exhibit A is admitted without objection.
And on this document, does it state that the defendant respectfully requests the court to submit the issue of community supervision to the jury and allow the introduction of evidence of the facts herein? Is that fair to say?
Yes.
And it also swears that the defendant has never been convicted of a felony in this or any other state.
Yes, that's what this reads.
I'll pass witness.
I have a question on it.
All right. Defense, call your next witness,
Okay,
and you may step down as the witness excuse.
Yes, sure.
If you'll remove the microphone.
Let's see what it is.
Thank you.
the defense calls Sean Bohack.
If you'll take a seat here, please.
Yes, ma'am.
All right, and you'll please put the microphone on. It's the square one somewhere on your tie or suit. It's for the court reporter to hear. If you can raise your right hand, do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Officer Sean Bohack.
All right, if you'll keep your voice up so that everyone can hear, you may proceed.
Thank you, Judge. Good morning, Mr. Bohack. Can you please tell the jury what your current occupation is?
I'm a pretrial bond officer, level 3, in charge of GPS defendants that are on ankle monitor.
Okay, so does that mean individuals that are accused of offenses that are out on bond?
Yes, sir.
Okay, and so they're individuals where their case has not been resolved yet, is that fair to say?
Yes, sir.
And they're either waiting for, and once that case is resolved one way or another, whether that's a plea, a trial, or a dismissal, that individual remains out on bond.
Yes, sir.
And so a court can order GPS monitoring as a condition of bond.
Yes.
Can you describe the different levels of GPS monitoring?
Well, so there's GPS full house arrest, which is a 24-hour, 24/7, 365 lockdown schedule, where the only places you can go is to meet with your attorney, to meet with your bondsman, to report to the pretrial office, to go to court, and for medical appointments and medical emergencies. There was a recent amendment for CPS child visitation as well. Now, all of those appointments need to be requested and confirmed no less than 24 hours in advance during business hours. Anything submitted outside those times can't be approved because if you can't see it, we can't approve it. Partial house arrest, the one addition that's made it is employment opportunities and school. So when we would just need proof of employment and then like a course schedule and enrollment. And then there's tracking, which is free movement within a 75-mile radius of Bexar County. Anything beyond that would need either a travel permit or a court order.
Okay, and did you supervise an individual by the name of Tyler Ashbaugh?
Yes, sir.
Do you recognize him in the courtroom today?
Yes, sir.
Can you point to him and identify an article of his clothing?
He's right over there with the white shirt and I believe a sage green tie.
Your Honor, may the record reflect that the witness has identified the defendant.
I mean, the record reflect what it was, yes.
And so you supervised Mr. Ashbaugh for quite some time, is that fair to say?
Yes, sir. I want to say he was on my caseload for about a year at least.
Okay, and so essentially for the last year, you've been in charge of monitoring and keeping in touch with Mr. Ashbaugh while he's been on GPS.
Yes, sir.
Can you describe his compliance with GPS and its conditions?
I mean, aside from the occasional forgetting to charge your monitor consistently on time or leaving a little earlier, getting back late due to traffic, no real issues.
Was Mr. Ashbaugh polite?
Yes, sir.
Was he hostile to you in any way?
No.
Are you aware if he was arrested at any point while on GPS monitoring?
I do not believe he had any additional arrests unless a warrant was issued due to a bond increase or something pertaining to a case he was already on monitor for.
But you're not aware of that?
No, sir.
Okay. So he didn't give you any hassle in any way?
No, sir.
Okay, I'll pass the witness.
No questions.
All right, is this witness excused?
Yes, Judge.
All right, if you'll leave the microphone behind, please. Defense, you may call your next witness.
Thank you, Judge. Defense calls Roderick Barnes.
All right, if you'll take a seat here, please.
Yes.
Here. All right, if you'll put on that small square microphone for me somewhere on your suit, it's for the court reporter to hear.
Yes, ma'am.
If you can raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I swear.
All right, you can lower your hand. Make sure you keep your voice up so that everyone can hear.
Yes,
If you'll
ma'am.
state your name for the record, please.
My name is Roderick Leon Barnes. I am a senior.
All right, you may proceed.
Thank you, Judge. Good morning, Mr. Barnes.
Good morning.
Can you please describe your current occupation and work to the jury?
Sure. I am bivocational. And so my wife and I, we own a small consulting firm in San Antonio. We do business intelligence for the military and private industries. I also pastor a small church in San Antonio.
Okay, sir. And have you come to know an individual by the name of Tyler Ashbaugh?
I have come to know Tyler Ashbaugh through my work with Compass Church.
Okay. And do you see him in the courtroom today?
I do.
Can you point to him and identify an article of clothing that he's wearing?
I see Tyler Ashbaugh sitting to your left wearing a white shirt and a gray tie.
Thank you, sir. Can you describe how you came to meet Tyler Ashbaugh, how you two came to know each other?
Yes. I knew first his family, his younger sister attends our church. I've been there for a little over a year and a half. One day I saw her brother and I saw Tyler at the church. This was some months ago. And then someone in the church asked me, had I met or talked with Tyler, and that they recommended or encouraged me to do so. I had not met him yet. Some months ago, after one of the services, he and I talked for a bit, and that was my first meeting with Tyler.
So he was in the congregation. Is that how you first recognized him or first saw him?
That is correct. I saw him in the back holding his baby once as I walked around the back in the church, and I saw him on a row with his sister and his brother, Josh.
How would you describe his engagement when he would be there in church?
Yes. So I watch people fall asleep or I watch people text. I see the whole gamut of why people are in church. Tyler evidenced when I talked with him after one of the services that he is dialed in. He was able to discuss what had been said. Beyond that, he has been in a small group with me. And in that context, his questions, his interactions were of a person who is paying attention and ruminating over what is being said.
Okay. And so some individual was stating that he wanted to speak with you. Is that what you said?
That is correct. Kathy Sullivan, a lady who works at our church, asked me repeatedly, had I talked with Tyler? The first time I had not. And she asked me again. And so I said, yes, I would talk with Tyler. He indicated that he wanted to get baptized.
And what was your impression of that wish?
I am generally cynical by nature. I think everybody needs a second chance, but I generally, when I hear a person wants to get baptized, I want to know why. And when I talked with him, I felt fairly certain his reasons were the right reasons. And so we had a chance also to talk at a Chewy's restaurant after that.
Okay. Can you describe his engagement and participation in that conversation with you?
Sure. Tyler was very transparent. He mentioned that he had made mistakes in the past. I listened to see if in describing the past, if he was merely there or he said, no, I made mistakes. And so he and I talked about that. He talked about his background, his family, a very difficult relationship with his mom. He asked me, should he try to reconnect with his mom? He was afraid of the influence. He wanted to respect his mother, but he did not want to be influenced by being around her.
And so how would you describe Tyler's, I guess, intelligence and thought process and speaking ability with you?
Yes, highly intelligent. I did not realize right away that he had the church background or background with the scriptures that he did, but his vocabulary was indicative of someone who had at least read. And as we had the conversation, he wasn't naive about what he was deciding to do. And that's where my questions were. You know, are you understanding what you're saying? And I got the impression he really was thinking hard about it. I say that because at my company, we will pick up from time to time people who've made mistakes, and at our technology company, we'll bring them in. There's another young man, he's made mistakes. He doesn't gainsay those mistakes. He doesn't try to diminish them. He had made mistakes. And he is also very intelligent. We brought him in. He's studying to be a DBA. And so one of the things that I was wondering is if Tyler would be able, I didn't know about all of this, but I knew he had a court case coming up, but I was wondering if he would be willing to work with me afterward. And I even asked Tyler that, say, hey, would you come up and work with me? Would you be with me at the church and potentially work in technology?
And do you feel like he would be somebody that you could trust?
I do. I always want to know, do people proactively tell me about the past or do I have to dig? I did not have to dig.
Okay.
He proactively said, hey, I've made mistakes. These are the things that have happened. That coupled with high intelligence demonstrated in his conversation and seeing him not as a flash in the pan, he's at church, but he can actually discuss what has been said. Those are the things that made me want to ask. And I don't ask. My company has a security clearance. I have a security clearance. I can't mess around with people who are playing games. So I wouldn't have asked unless I thought he could be trusted.
Okay. And did you think when Tyler was, when you would speak with Tyler that all of this was genuine?
I did. I thought what he was saying was genuine.
Okay. And did Tyler express an interest in getting more involved with the church?
He had a cautious expression. I mean, he repeatedly said, I would like to, but I don't know how this is going to turn out. I really would like to, but I don't know how. And so he said that repeatedly. At the time, I didn't realize the gravity. But my hope is that he would be someone that I could work with because he evidenced an interest and he has the kind of mind that could do technology and he wants to walk with God. Those are the two things I was looking for.
Okay. If this jury were to give Tyler probation and he was supervised by the court, would you try to assist Tyler to make sure he stays on the straight and narrow path?
If Tyler were to be given probation, I have a fairly strict program. He would have to be in a men's fellowship with me and some other men. He would work with me every day. Every day. He'd have to be with me at the office every day. and he would have to be in attendance at the church. None of those things are a guarantee, but my history, and I've been doing this for decades, my history is people who choose to be in that company on their own and they are reliable, they change. And he is a person that I've seen some changes already in my brief time knowing him over the past few months. And in an environment like that where he can get good counsel and be in the company of people, a cadre of people who want to do right, I am confident that he could change tremendously.
Okay. And how would you describe Tyler to somebody that's never met him?
Just candid. Thought he was a Jew because he's got a really big nose. So I don't know. I would have said Jewish kid, and really intelligent, kind of nerdy, knows scripture really well, and needs a chance. That's how I would have described him. Didn't realize, he's married, he's got 2 kids, and that was a delight. I saw him holding the baby at the back of the church. Later, I find out that's his, and then I meet his wife. I describe him as a family person as well. I mean, unprompted by me in our conversations, he just keeps talking about his wife, keeps talking about his wife, keeps talking about his kids. And so I would describe him as a young family man, looking kind of nerdy and wanting to do the right thing.
Okay, I'll pass the witness, Judge.
Any questions?
Just briefly. Mr. Barnes, you stated that over the last couple of months, you've gotten to know Tyler. So exactly how long have you known him?
I can't say more than 3 months.
Okay.
Yeah.
And in those 3 months, he's attended your church?
That is correct.
Okay, and is that a non-denominational Christian church or what kind of church is it?
It is a non-denominational Christian church. It's located off of Bandera Road, just outside of the Loop in Helotes, Texas.
Okay. And so you said if this jury were to give Tyler probation, I'm assuming you said that he would be with you every day. Is that what you said?
I have a small technology company. If he were willing to do that, I'd want him like the other guy, if I may say his name is Jason Burkett. I'd want him to join the ranks at our company.
Okay. But there's no guarantee, even if he did do that, that he would be able to be with him every single day. Is that correct?
Saturdays, I'm generally not. So I used hyperbole there. I generally wouldn't be with him on a Saturday. I'm with family. And Mondays, I come in later because I'm bivocation.
Okay. And then even, I guess, regarding the church services, I mean, there's no way that you can guarantee to this jury that he would participate in the men's program or continue attending church on Sunday.
I can only turn in reports if I were involved. If he were granted that, then I would regularly report. This is what he's doing as far as what he's been asked to do.
Right, but I'm saying there's no way that you could guarantee or ensure.
For anyone. I can't guarantee that for anyone.
Okay, we pass the witness, Your Honor.
Just briefly, Judge.
Mhm.
And you stated that you had come in contact with Tyler within around the last 3 months.
Yes, sir.
Were you aware if there was a change in his GPS status around that time that allowed a little bit more freedom?
I was not.
Okay.
I saw him there. I didn't know about the GPS status thing until about a month and a half ago. So I wasn't aware of that, but in our conversation, he made mention of it. So-
I'm sorry, just 1 second.
Yes, ma'am.
Once an objection is raised, I know it's sometimes maybe
Oh, I'm
it's hard to
sorry. I
hear.
didn't hear the objection.
Yes, you just have to stop talking.
Yes, ma'am.
All right,
My
what is your,
apologies.
no problem. What's your objection?
Hearsay.
All right, that'll be sustained.
Without saying what anybody told you, were you aware at some point when you met him that his GPS status had recently changed?
I was not aware.
Okay, I'll pass the witness.
No further questions and excused by state.
Excuse?
Yes, Judge.
All right, if you'll remove the square microphone, please.
Yes, ma'am.
Call your next witness.
Defense rests.
State, any rebuttal witnesses?
No, Your Honor, we rest and close.
All right, defense, do you close?
Yes, Judge.
All right, ladies and gentlemen, just give us about 10 minutes and then both parties will have a chance to present to you their closing arguments. Everyone, please rise for the jurors. And if you all can, everyone be seated, if you all can review those and let the court know if there are any objections. And gentlemen, you've received all the evidence that you're going to receive for this phase of the trial. I'm going to read to you the charge of the court. You do not have to memorize it. You will be given the original when you begin your deliberation. Charge of the court on punishment. Members of the jury, the defendant Tyler Ashbaugh has been found guilty by you of the offenses of aggravated assault against a public servant as charged in counts 1 and 2 of the indictment, and deadly conduct as charged in count 3, paragraph A of the indictment. The court has granted the state's motion to waive count 3, paragraph B. The repeat offender enhancement allegation paragraph of the indictment alleges that, I'm so sorry, just one moment. Cindy.
Yeah. Thank you.
Right, the repeat offender enhancement allegation paragraph of the indictment alleges that before the commission of the offenses alleged in the indictment on the 8th day of February 2017 and cause number 2015 JUV 01255D in Bexar County, Texas, the defendant was adjudicated by a juvenile court under section 54.03 Texas Family Code for delinquent conduct constituting a felony offense for which the defendant was committed to the Texas Youth Commission under section 54.04D2 Texas Family Code for the felony of burglary habitation force. To this allegation in the repeat offender enhancement allegation paragraph of the indictment, the defendant has pleaded not true. It now becomes your duty under the law to determine whether the repeat offender enhancement allegation is true or not true, and to set the punishment which should be assessed against this defendant in each count. With regards to counts 1 and 2, if you believe from the evidence beyond a reasonable doubt that all the allegations set out in the repeat offender enhancement allegation paragraph of the indictment are true, you will state in your verdicts in count 1 and 2 that you find true the allegations in the repeat offender enhancement allegation paragraph of the indictment and assess the punishment of the defendant at confinement in the Texas Department of Criminal Justice Institutional Division for life or for any term of not more than 99 years or less than 15 years in counts 1 and count 2. In addition to imprisonment, you may assess the fine not to exceed $10,000. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in each verdict. With regards to counts 1 and 2, if you do not so find beyond a reasonable doubt that all of the allegations set out in the repeat offender enhancement allegation paragraph of the indictment are true, or you have a reasonable doubt thereof, you will state in your verdicts in count 1 and 2 that you find the allegations in the repeat offender enhancement paragraph of the indictment not true, and assess the punishment of the defendant at confinement in the Texas Department of Criminal Justice Institutional Division for life or for any term of not more than 99 years or less than 5 years in counts 1 and 2. In addition to imprisonment, you may assess a fine not to exceed $10,000. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in each verdict. With regards to count 3, paragraph A, if you believe from the evidence beyond a reasonable doubt that all of the allegations set out in the repeat offender enhancement allegation paragraph of the indictment are true, you will state in your verdict in count 3 that you find true the allegations in the repeat offender enhancement allegation paragraph of the indictment and assess the punishment of the defendant at confinement in the Texas Department of Criminal Justice Institutional Division for any term of not more than 20 years or less than 2 years in count 3, paragraph A. In addition to imprisonment, you may assess a fine not to exceed $10,000. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in your verdict in count 3, paragraph A. With regard to count 3, paragraph A, if you do not so find beyond a reasonable doubt that all of the allegations set out in the repeat offender enhancement allegation paragraph of the indictment are true, or you have a reasonable doubt thereof, you will state in your verdict in count 3 that you find the allegations and the repeat offender enhancement paragraph of the indictment not true, and assess the punishment of the defendant at confinement in the Texas Department of Criminal Justice Institutional Division for any term of not more than 10 years or less than 2 years in count 3, paragraph A. In addition to imprisonment, you may assess a fine not to exceed $10,000. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in your verdict in count 3, paragraph A. If you assess a fine, it is not paid to the victim or victims, if any, but is paid into the registry of the court. You are also instructed that when there are separate punishments on multiple accounts, whether those sentences run concurrently or consecutively, that is, at the same time or one after another, is a decision to be made by the court. Our statute provides that where a defendant is found guilty of the offenses of aggravated assault against against a public servant in deadly conduct, and the jury finds that the defendant has never been convicted of a felony in this or any other state, the jury may, within its discretion, recommend to the judge that the judge suspend the imposition of the sentence and place the defendant on community supervision so long as the sentence assessed is 10 years or less. If the jury does recommend community supervision, it will be granted by the court. The defendant in this case has applied on written sworn motion for community supervision, stating, among other things, that he has never been convicted of a felony in this or any other state. A juvenile felony adjudication does not bar the defendant's eligibility for community supervision. If there is any evidence before you that the defendant may have previously committed acts of misconduct other than that for which you have convicted him, you are instructed that this evidence, if any, was admitted to assist you, if it does, in determining what sentence is appropriate in the case at hand. You may consider that evidence in assessing punishment only if you first believe, beyond a reasonable doubt, that the defendant committed such act of misconduct, if any. In the event you have a reasonable doubt as to whether any other such act or misconduct was committed, or as to whether the defendant was involved in such other act of misconduct, then you will wholly disregard the evidence, if any, which may relate to any such matter. You are instructed that the defendant may testify in his own behalf if he chooses to do so. But if he elects not to do so, that fact cannot be taken by you as a circumstance against him, nor prejudice him in any way. The defendant has elected not to testify in this punishment phase of trial, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or taken in consideration for any purpose whatsoever. In your deliberations, you may consider evidence introduced during the guilt phase of the trial, as well as any evidence at the punishment phase of the trial. Under the instructions herein given, it will not be proper for you, in determining the penalty to be assessed, to fix the same by lot, chance, any system of averages, or any other method than by a full, fair, and free exercise of the opinion of the individual jurors under the evidence admitted before you. The length of time for which a defendant is imprisoned may be reduced by the award of parole. Under the law applicable to counts 1 and 2, if the defendant is sentenced to a term of imprisonment, the defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed, or 30 years, whichever is less. It cannot accurately be predicted how the parole law might be applied to this defendant if sentenced to a term of imprisonment, because the application of that law will depend on decisions made by the parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. Under the law applicable to count 3, paragraph A, the defendant, if sentenced to a term of imprisonment, may earn early parole eligibility through the award of good conduct time. Prison authorities may award good conduct time to a prisoner who exhibits good behavior, diligence in carrying out prison work assignments, and attempts at rehabilitation. If a prisoner engages in misconduct, prison authorities may also take away all or part of any good conduct time earned by the prisoner. Under the law applicable to count 3, paragraph A, if the defendant is sentenced to a term of imprisonment, the defendant will not become eligible for parole until the actual time served plus any good conduct time equals 1/4 of the sentence imposed. Eligibility for parole does not guarantee that parole will be granted. Suitable forms are attached hereto for your verdicts if you should care to use the same. However, such forms are not intended to influence you in any way in arriving at your verdicts. In any event, each verdict must be unanimous, in writing, and signed by all of 11 of you. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. Are both parties prepared to proceed with closing?
Yes, Your Honor.
Yes, Your Honor.
All right, state.
Thank you, Your Honor. It's counsel. Ladies and gentlemen, I'll be, again, third to last to speak to you today. Defense counsel will have an opportunity after me, and then Ms. Galloway will be the summation of our closing argument punishment. One thing that you might notice on there is that the state has chosen to waive paragraph B of count 3. We're proceeding just with that count 3A. Nothing of your concern. It's the same amount of time possible, but that's just to clean it up a little bit going forward. One thing that I did want to point out to you is that the state exhibit number B, proved beyond a reasonable doubt. Tyler Ashbaugh committed this and served time in TYC for this felony. That's that enhancement paragraph. Find that beyond a reasonable doubt. Really, there's no choice. He has to be sentenced at least 15 years minimum, up to 99 years or life in prison. That wasn't y'all's choice. Y'all didn't choose to go into that house or verbally have a habitation. Y'all didn't choose that. Y'all shouldn't feel guilty for making that decision. He's the one that made that decision in his past. He's the one that has to pay for that now. I think we can all say that we feel for even him, but we also feel for his family. He had good parents. Well, his parents that took over. He had that opportunity. Unlike a lot of other individuals out there, he had an opportunity, at least by the time of 7 years old, because where he sits now, he had that opportunity. He chose unwisely. It was his choice. He was convicted of this. For adjudication of this juvenile, it's a repeated offense. It's been proven beyond a reasonable doubt. Even in this, he had choices, and he was revoked off that probation that he received there. That was his choice. Just like in this case, his choice to go that night and drink, smoke marijuana, and shoot that gun at these police officers. So you, as a jury, do not feel guilty for that. Those are his choices. So when you get to some of this legal language where it says the juvenile felony adjudication does not bar the defendant's eligibility for community supervision, that's accurate. That's stated accurate. But don't get confused, because when this is proven beyond a reasonable doubt, which it has been, that count 1 and count 2, the minimum is 15. You heard Ms. Zapata on the stand that if the maximum rather is 10 years. So probation is really not an option in this case. That has been taken away, not by you, by the individual's past history and what he's done. So really, when you get to the verdict forms, and I've highlighted mine, you go to count 1, punishment. It's going to read that first paragraph, and it's going to say assess 15 years to 99 years of life. And there's a box there. That's where you fill in the amount of time. And I'll state this, the fine, I think this judge has said it before. I don't know about this case, but I don't know where the fine goes. It doesn't matter about the fine. Don't get caught up on the fines. Going to count 2, again, it's that first paragraph, number 1. There's a space for 15 years to 99 years of life. And then getting to count 3, paragraph A, with that enhancement paragraph, it takes it to 2 to 20, and that's where you appropriately put it. You don't need to go past that. At that point, that's the amount of time that's assessed. It's not your choice. It wasn't your choice. It was his choice. He made those choices. I feel for the family, the father, the mother, and his wife. Feel for his children. The choices have consequences. And today he has to answer for them. It's not a burden that you have to carry. It's his. It's 15 years to life on those count 1 and 2, and 2 to 20 on count 3. Thank you for your time. And I'll be reserving my remainder of time for Ms. Gallagher.
All right, defense, you may proceed.
Thank you, Judge, Counsel. It's good afternoon now. They said that it's not your choice. Whether or not to present this enhancement, that is their choice. Do you think if it was any of us, and I've never seen a juvenile enhancement until this case, do you think if it was any of us in that parking lot, that they would be presenting a juvenile enhancement with that qualifier? I see that in it, and it breaks my heart. It says a child. To force you to not be able to consider that full range of punishment. That's the difference in 15 years and allowing him to continue what he's done. You've seen his amazing support system. They all came in here, talked about what an intelligent young man he's become, how he's changed. He's a good dad. He's a good husband. You heard his pastor. He'll vouch for him. All these people that are willing to help him continue the path that he's already on. It would be one thing if he was out on bond and then you hear he's not even taking this seriously anymore. You know, he's violating his GPS. He's drinking. He's smoking. He's doing all this. He's been a family man since then. He's been on full house arrest. He's gotten a little bit more freedom. He's never abused that freedom. Those little extra liberties that he's been given. Because this is a serious charge. And so I know you all looked at the evidence very closely. And like I said, personally, I disagree, but I don't hold anything against you. I know that you guys looked at it with, you know, as much care and attention as you possibly could. And so I appreciate all your service and everything you've done these last 2 weeks. And so there is a reasonable doubt. You heard the fingerprint person testify. You have to believe that that's proven beyond a reasonable doubt. Expect more. Look at all the evidence they brought you for guilt, innocence. And for punishment, all they do is they have a fingerprint person come in, look at the person that's obviously on trial, compare that guy's fingerprints. They don't even do it blind. They just say, you know, this is the guy on trial. Take his fingerprints, compare it to these other ones that are in this judgment that allege other wrongdoing. It's a very prejudicial process. Look at this guy, compare it to this stuff that allegedly happened when he was a child. And he stated that it's a subjective science. Subjective means there's a lot of interpretation. Well, that sounds more like an art to me than a science. And he stated that the standard method is the ACE-V method. And it's ACE-V. The V is important because he said every expert can come up with a different opinion on this fingerprint. It's up to the individual expert. It's up to their interpretation. That doesn't sound like a science to me. And so that's the most important part of the process is that V, the verification. So you have somebody disinterested, doesn't know who's on trial, compare these fingerprints and see, is it the same person? And they didn't do that. He admitted, I did not comply with the standard method for doing this. Now, we've been in this courtroom all together for 2 weeks. You've shared it with me, the prosecution. You've shared it with my co-counsel, and you've shared it with Tyler. There's no monsters in this courtroom. You've heard him testify. You've heard his family testify. You've heard everyone testify. If you thought about this charge, I bet you didn't picture this person and this support system and everything that he's done since then to try to become a better person. Now, I also want you to think about the gravity of the situation. Like I said in the guilt innocence closing, the currency now you're deciding is either probation or years of human life. What were you doing 1 year ago today? Think about all the experiences you had. Think about all the experiences with your children, with your family, your holidays, your peaceful moments, your good times, your bad times, your triumphs, your failures. Now just delete all that. And that's one. That's just one. And so they're asking you to say that you don't have a choice. But they took that choice away from you because there was a lot of pressure on them in this case. That was my biggest fear in
I'm
this
gonna
case.
object, that's improper argument.
Sustained.
There was a tremendous amount of pressure in this case to support police officers. You think in every case they track somebody's phone, they get fingerprint, DNA, all this stuff, every single type of scientific evidence imaginable. And so based on all that pressure, now they want you to say you don't have a choice, and with something that they're going to present to you that says they don't want you to consider probation because they want you to believe Tyler Ashbaugh was a very bad child. A child. That makes you feel a little off. I think it should. It's not right. There was reasonable doubt. That expert testified, the fingerprint person testified that he didn't do it according to the standard method. I'm proud to be Tyler's attorney. I'm not going to make any excuses for that. I'm asking you to decide that there is reasonable doubt. In that jury charge, it says if you have one reasonable doubt, it's just, and remember in jury selection, we said, it doesn't matter how big or how small. The person testified if it was that pill and there was an outbreak, and I would not go buy a Tylenol bottle for my child if there was that tiny chance that I bought one across the nation and it would poison them. We'll demand more and expect more. The expert is saying this is subjective. That's not a science. You're basically just looking and kind of basing it on vibes. Does it look the same as this? And using a lot of technical terms, we'll know two people have fingerprints. Okay, well, there's got to be a better way than this. They could have brought people that said, yeah, I was an employee at this juvenile system and I saw Tyler there and he was booked for this and all of that. And instead, all you have is people saying, yeah, I don't know what it was for. I think it was this. Demand more, expect more. There is a doubt and it is reasonable. You are reasonable to believe that. It doesn't matter how big, even if it's the tiniest doubt, as long as it's reasonable. Then you can consider the full range of punishment. In this case, 5 to 99. And if you give a number that is 10 or less, then there's going to be somewhere on that judgment where you can recommend to the judge to grant him community supervision. That's what I'm asking you to do. Restore Tyler to his family. He hasn't abused the trust that the judicial process has given him. He was on full house arrest. He couldn't go anywhere. He was just stuck in his home. And what did he do? He became a better father. Tatiana trusted him to take care of their child. And then he gets a little bit more freedoms. Partial house arrest, where he can actually work, help provide for his family. Also, and before that, he was given the opportunity to take his kids to and from school. And now most recently,
2 minutes.
Thank you, Dinesh. Now most recently, a heck of a lot more freedom, where there's really no restrictions on where he can go. It's just we're monitoring you, we know where you are at all times. And he hasn't abused that. What did he do once he got to that point? He went and he attended that church, and Mr. Barnes told you this wasn't, he didn't think he was phony. He says, I can tell when people are being phony, and there's a reason for this. He's a genuine person. I believe him. I think he's redeemable. I think he's not a monster. I'm just asking you to give him the ability to do what he's doing. This judge, if he violates, he'll come right back to this court. And they told you all of the different conditions and how onerous that can be. And this is a very proactive judge, I will say that. She works very hard. And she She tries to get to know all the people that come before her. It's a very good quality that she has. And so if Tyler needs any help or he's struggling, she's going to get it for him. She's also going to be very strict and demand that he comply with all the conditions. And you heard all the conditions. It could be as onerous as going into a facility. It could be all the way up to 10 years of probation. He's already a convicted felon. That ship has sailed. Can't own any firearms. But you can trust him because he hasn't violated this judge's trust every step of the way. And so I'm asking you to give a number that's 10 or less. That's the only way. You have that application swearing that he's never been convicted of a felony. What a strange law. A juvenile adjudication is not a felony conviction for probation eligibility, but only for purposes of enhancement. And you can rest assured, if there was any way to counter that, they would have done that. But Tyler has not been convicted of a felony.
Time.
Thank you. And I'm asking you to grant him probation.
All right, state you have 5 minutes and 30 seconds.
Ladies and gentlemen, at the start of this trial, you all took an oath to follow the law. And what they're asking you to do by finding the enhancement paragraph not true is violate that oath. We have proven the repeat enhancement.
Judge, I'm going to object to that improper argument of saying that my argument is to have them violate the law. It's well within our bounds to say they haven't proven this beyond a reasonable doubt.
All right, ladies and gentlemen of the jury. You in the jury charge is the law. Does everyone understand that? That is the law. If attorneys argue outside of the law, that's to be disregarded. Does everyone understand?
And Judge, I hate to be a pest, but could I get a
Yeah.
ruling on that?
All right, that will be sustained.
And thank you. And may I get a limiting instruction? I think you just,
All right, ladies and gentlemen, you did disregard the last statement by counsel.
and I'd ask for a mistrial.
That will be denied.
We have proven this repeat enhancement allegation beyond a reasonable doubt. Now, if you choose to disregard Robert Jimenez and his testimony of being a fingerprint examiner for over 30 years, let's just look to the testimony of Tatiana and Mr. Joseph Gonzalez. They've known the defendant his whole life. They both testified that he was sent to TYC for committing the felony offense, okay, of burglary of a habitation with force. What is that? That is a violent crime. That is breaking and entering into someone's home without their consent. Okay, he was placed on juvenile probation for that. He was given a chance. He couldn't put the drugs down. He couldn't stop carrying deadly weapons. And then shortly after that, that was in 2017. Okay, and 4 years later, he commits the acts that you adjudicated him guilty of. He has not learned his lesson. Okay. Now, the state is asking you to assess, to deny his application, find the repeat enhancement true because we proved it beyond a reasonable doubt, and sentence to the defendant to 20 years in prison on counts 1, 2, and 3. And I'm going to explain to you why we are asking you to do that. Notwithstanding just the acts that he committed on that date. Okay, the ones that you adjudicated him guilty of, but you also get to take into account the other crimes that he committed on that night. Driving while intoxicated. He's still committing offense by driving without a valid license. You know, they bring this pastor in who's only known him for 3 months and he's gonna get up there and vouch for his personality. You can't get to know someone well enough in 3 months to say, hey, I can vouch to you that I'm gonna be responsible for this person. That's impossible, okay? Regarding probation, he's ineligible because the minimum is 15 with the true repeat enhancement allegation by finding it true. And so what would that look like? Okay, Ms. Zapata stated that there is criteria that has to be met to even be sent to the facilities that are lockup. So we don't know what's going to be the result of that. Probation cannot guarantee that he's not going to still possess firearms. They're not going to be going to his house every day and conducting searches and seeing what's in his home. And Mr. Navy was asking all of the witnesses, are you going to do everything that you can to ensure that he complies with his probation? Well, I'm sure that Tatiana and Mr. Gonzalez tried to do the same thing when he was on juvenile probation. And look at where that ended up. He was given many chances. And ultimately, he left that court with no choice but to adjudicate him. Those are choices that he voluntarily made and that he has to pay for. Now, there's been a lot of tears in here, but I want you to take note. The only reason that there are tears is because you all forced him to take accountability for his actions.
Objection,
They're
improper
crying for
argument.
themselves.
That will be
Striking over
overruled.
the shoulder of counsel.
That'll be overruled.
They're crying for themselves. There were no tears for the officers or their families or the fear that they felt on that night. There was no crying then. No, he had a joyous time getting up on that stand and telling you all complete lies. Those are things that can't be disregarded. And he's never made the change on his own. A person can only change if they want to. Tyler does not want to change, okay? He's doing these things because he's on the ankle monitor. He has to live. He has no other choice. He has no other choice but to comply with those terms. He's not doing it on his own. He's doing it because he has to, because it's a condition of his bond, because he knows that if he doesn't comply with that, he's going to be in the Bexar County jail awaiting trial instead of with his wife and kids. He's been given multiple chances. Also, you learned during
1
this
minute.
time, he was engaging in the sale of marijuana for extra income. That is behavior. He is not a law-abiding citizen. That is behavior that cannot go unpunished in our community. Okay, Mr. Navy wants to talk about pressure. Yeah, my job does involve a lot of pressure because I'm like that table. I have a duty to the community to protect the citizens of this community.
Objection, improper argument.
All right, that'll be sustained.
And judge had asked for limiting instruction on that argument.
All right, ladies and gentlemen, you're to disregard the last statement.
And I'd ask for a mistrial.
That will be denied.
Ladies and gentlemen, we have proved that enhancement paragraph truth beyond a reasonable doubt. And so we are asking you to sentence the defendant to 20 years in prison on counts 1, 2, and 3. Thank you.
All right, ladies and gentlemen, Deputy Laura will take you to the back to begin your deliberations.
All right, for the jury,